Selling your house produces a complex mix of emotions, no matter if it's your first or your fifth time. This guide will help you better understand the title and escrow part of selling your house. Provide important information you need to know, and Michael Sorensen will offer some handy tricks to keep in mind along the way. Title is evidence of lawful property ownership. By holding title, you or those whom you share title with have legal ownership rights and bear responsibility over that home. Title insurance is a form of insurance that protects lenders and homebuyers from financial loss sustained from defects in a title to a property. Title insurance is a non-transferable, one-time purchase made during the settlement and closing process of buying a home that offers you security against unforeseen circumstances that could impinge upon or even revoke your ownership rights. The causes of these title defects are numerous and wide-ranging. The most common type of title insurance is owner's title insurance, which may be paid for by either the buyer or the home seller to protect the buyer's ownership rights in the property and to assure the buyer that any title issues related to past events do not become problems in the future. The other type is lender's title insurance, which the borrower, usually a home buyer, purchases to protect the lenders, the company giving the buyer the deed of trust/mortgage, equity, lien position in the property. This form of title insurance is often a requirement from the lender to procure the loan. Title and deed. They are different. However, they deal with the same concept of home ownership. The biggest difference between a deed and a title is physical. A deed is an official written document declaring a person's legal ownership of a property, while a title refers to the intangible concept of ownership rights. A warranty deed, which is just one type of deed, is a legal document that transfers property ownership from a seller and/or grantor to a buyer and/or grantee. Included in this transfer is a guarantee that the buyer will receive what the seller said was being sold. In a deed, you will find a legal description of the property, including any property lines, the name of the seller and/or grantor, the name of the buyer and/or grantee, and the seller's signatures to make the document legal. It is important to note that there is a difference when transferring ownership between personal property and real property. Personal property includes things like a boat or car, while real property is the raw ground and anything affixed to it, house, outbuilding, etc. This is why, in the legal sale and/or purchase of real property, the title transfers to the buyer along with the deed. A title search is an examination of public records to determine and confirm a property's legal ownership. It also identifies if there are any claims on the property that must be settled prior to or potentially prohibiting a transfer to a new owner. A claim in this sense can be thought of as a statement from an entity or person that is not the current title owner declaring some type of right to the property. Claims that might come up in a title search include a legal right or claim against a property by a creditor, also known as a lien. As an example, your construction team forgot to tell the county clerk you paid off your bathroom renovation. Should you have any questions regarding the deed or the title, reach out to Michael Sorensen at 9413802900 or Mike@housemike.com.